Welcome to The Explainer. Okay, let's dive into a court ruling that could change, well, everything.
And thanks to a recent BC court ruling, this is no longer a hypothetical question. It all stems from this landmark case, Cowichan Tribes versus Canada's Attorney General. So how did we even get here? Well, our story starts back in the 1800s. Here's the key detail. Colonial officials just sold the land right out from under them. So generations later, the Cowichan Nation took this fight to court, setting up a major legal showdown. Their claim was for Aboriginal title, a right to the land they've occupied for centuries. The government's argument? Fee simple ownership, which they claimed wiped out any other rights. So you've got these two powerful titles on the same piece of land. Which one is stronger? And get this, the court took 513 days to answer that, one of Canada's longest trials. The decision that came out was absolutely groundbreaking. It kind of rewrote the rules for Canadian property law. Bottom line, the court said Aboriginal title is the senior right and the original Crown grants were invalid. The judge's exact words were that the grants were an unjustifiable infringement on Cowichan title. But to avoid total chaos, the court suspended its decision for 18 months. Time to negotiate. The whole idea is to force the governments and the Cowichan Nation to sit down and talk. Okay, so what's happening now? Well, this is where things get complicated. Because instead of negotiating, the feds, the province, and the city all decided to appeal. And those appeals have pretty much frozen the entire process, while that 18-month clock is ticking down. For their part, the Cowichan Tribes say they're not after private homes, just government-held lands. So why should you care? Because this case could set a huge precedent for land titles everywhere.
This one ruling really challenges over 150 years of land policy. It leaves us with a huge question.